Hello, everybody. Welcome back to the University of Florida e-Discovery Conference. Thrilled that you're back with us for the next session this afternoon, which is on proportionality. And if you know e-Discovery, you know proportionality is the buzzword of the day. We've got a great panel. I'd like to invite them on the stage right now, led by Mike Cortaro, the president of the Association of Certified e-Discovery Specialists. Mike, if you and your panel will run with it, I would appreciate it. Please introduce them, and thank you so much.
Thank you, Bill. Please tell me you can see the slide.
We can see the slide.
Fantastic. Hello, everyone, and welcome to Proportionality in Practice. We'll get to our panel in a minute. Experience from the trenches. My name is Mike Cortaro. I'm the president of ACEDS, and I'm your moderator today. Before we get started, I think it's really important that we set the stage a little bit and talk about why we're here. Why should anyone care about proportionality in practice? I think about it like this. If you consider the arc of the life of litigation, we've graduated from a time years ago when the question was, can I find the evidence, to a time now when we ask, how do I filter all this evidence? We've gone from begging for evidence due to its scarcity to having an overabundance of evidence. So as practitioners, we've had to adjust our thinking, and I think the best way to think about this is to think of a tidal wave. We've seen a tidal wave of information in recent years, waves and waves of data. You see, we have a big problem, and the problem is one of scarcity versus abundance. Evidence used to be scarce, now it's abundant. We no longer have the time, the resources, the finances, or the ability to capture all this relevant evidence. We just can't. We now need to think about not what we need, but what we can find. We have to think about the trade-offs. We have to think about marginal cost versus gain. What does one more custodian get me? What does one more custodian cost? And by the way, the cost and the benefit of these data sources, it's rapidly changing. So it's a bit of a moving target. Why is proportionality a big deal? Why should you care? Because the growth of computers has shifted the search for evidence from a problem of scarcity to one of abundance, and we're just starting to realize this. Think of this analogy, Moses versus Noah. Big biblical reference here, guys. Moses was in the desert for 40 years. He could have used some water, right? What if he wrote the rules for water discovery? Noah, on the other hand, was in the ark for 40 days. What if he wrote the rules for water discovery? Moses is the attorney of yesterday, where we can't find enough evidence. Noah is the attorney of today. Holy moly, we have way too much evidence. So I think it makes sense to frame the question, the problem, as one of scarcity versus abundance. Proportionality in discovery solves for this problem. A lot of people do not realize that proportionality has been around forever. It was in the rules long before the 2015 amendments to the Federal Rules of Civil Procedure. It should not be anything new. As we're going to hear in a minute, many practitioners may have overlooked the rule changes, but obligations with respect to proportionality have really not changed. Indeed, as the quote here from the committee notes makes clear, the obligation to consider proportionality in discovery is the responsibility of both parties and the court. Okay, enough from me. I don't know about all you, but I had a hard time tying a tie today. It's been a while. Proportionality is our topic today. Let's turn to the greater minds. We're going to give you some excellent education and raise your awareness. We've got a stellar panel today. Let me introduce them really quickly. Each of our panelists is well known to the industry. They are practicing in the e-discovery space as we speak. First, we have Tessa Jacob, partner at Hush Blackwell. Next, we have Mandy Ross, CEO and Managing Director at Prism Litigation. And Ariana Tadler, Managing Partner at Tadler Law, joins us as well. And finally, we have Scott Milner, a partner and co-leader of the e-data practice at Morgan Lewis. Thank you to each of us for joining us. Let's get into it. We're going to start with a poll question. If I could have the first proportionality poll question put up, that would be fantastic. Are you familiar with the 2015 amendments to FRCP 26B regarding proportionality? Reminder for our panelists today, you can't vote. So we'll give them a second to fill out the poll. Pretty easy question. Let's see what we're getting here. Look at that. 63 to 37%. Let's close the poll and move on. And turn to our panel. Tessa, what are your thoughts on the survey? And can you explain to our audience what changed in the rules in 2015 as it relates to proportionality?
Thanks, Mike, and thanks, Bill, for having me here again this year. I always enjoy this conference. So the concept of proportionality has been part of the Federal Rules of Civil Procedure since at least 1983. It went largely unnoticed, however, because of the way it was framed, and later because the proportionality requirement was tucked into subsection G as part of the propounding party certification. So through a series of amendments, the proportionality requirements were softened, even though that was inadvertent. So as a result, few attorneys are reading Rule 26 proportionality requirements, much less heeding it. And so in 2015, the Advisory Rules Committee moved the proportionality requirement up to subsection B, restoring proportionality as an express component of the scope of discovery, and also this time actually referring to proportionality by name. So as you can see in the slide, Rule 26B1 spells out 6 specific factors that the court should weigh in making proportionality rulings. They're all listed here in the slide. If you have not done so, I would actually really encourage you to read the advisory committee notes to 2015 amendments. I did that again last night. It's really helpful to get some clarity on what the changes were meant to do. Because what I find is 5 years after the 2015 amendments, which gave really more clarity, prominence, and bite to proportionality rule, practitioners still seem to be struggling with how to use it. I see a lot of requests for any and all documents related to that relate or refer to any given subject. I also see a lot of objections that simply say that the request is not proportional. So today, our panel is going to discuss the best ways to bolster your proportionality argument and the best way to defend against a proportionality argument.
And before we move on, I think the answer to the poll question, it shows why we're having this panel. I think the fact that if I recall, it's like 63-37, if I recall correctly, that didn't realize proportionality was part of the rules, is why I think this was thankful. This is a good choice for us to continue with this panel and share some practice pointers on this issue.
So I echo that, what Scott just said. To see a poll like that makes it so critical that we really continue to educate the bar about how the rules work. I'm so glad we talked a little bit also about the committee note, because that's important in understanding how the rule is supposed to apply.
Exactly. Anything to add, Mandy?
No, I agree with everything that's been said.
Fantastic. Let's move on. So if you haven't noticed, we're going to start each of our topics today with a poll question. If we can get poll question number 2 up. Why do parties continue to argue about proportionality in discovery or fail to raise it in a meaningful way, particularly with respect to ESI? Please just take a moment, make your choice, hit submit, and we'll talk about it on the other side. I'm doing my best Brian Williams impression today. Or maybe it's Chris Matthews, I don't know. It's one of those TV talk show people who taught me how to talk in front of a TV. Fantastic. What do the poll results look like? Look at that. So let's leave those up for a minute. I'm going to switch slides, and I'm going to ask Ariana, what's your take? What's your take on the question and the poll results?
All right, so the poll results are showing that the majority of people think that there's a lack of understanding of the proportionality factors. And I think one of the things that would be really interesting to know for Bill to kind of query further after the conference is it recognizing what the factors are or recognizing and understanding how they work? Because I think that's the deeper dive that we're facing. To the extent that the other items were chosen, I think they're a little bit telling. I think people have had experiences that suggest that the issue of proportionality comes up in ways that sometimes just feels like more of the same, rinse and repeat, as well as, when you have a poor experience Studies often show that poor experiences sit with you more than positive experiences, especially if they're particularly negative. And so we want to educate as many people as possible to have more positive experiences so that the rule will be working and moving in the right direction because of that positive momentum.
Feels a little bit like Groundhog Day, doesn't it, Ariana?
And Ariana, I would love to ask your input because when you talk about poor experience, I don't know how many meet confers you've been a part of because we're generally on a requesting producing party side where somebody's coming to me and says, yeah, but in another case, somebody refused to do this and I don't trust you now that you're going to actually give me the discovery I deserve. And you can have all the dialogue in the world, but unless you build some trust and collaboration, it may not matter. So I'm curious if you've had that experience as well.
So sure. I mean, for me, I'm on both sides as well, requesting and producing. And in many of my cases, I see repeat lawyers because parts of the practice that I maintain relates to the class action bar. And so I see a lot of repeat players, some of whom are friends now, right? When you work in the trenches on cases that go on for many years, you end up building relationships that hopefully are positive ones. And when you have a negative experience, it's incumbent upon you to then determine, are you just going to let that negative experience fester with you and dictate how things are going to proceed, not only in future cases, but in your example, Scott, in the same case. Something went wrong, you had a bad meet and confer, or the result was not what you wanted on one particular issue. Is that now going to be the applicable mentality or dynamic for the entire case? I hope not. As you all know, I aim to be responsive, not reactive in all that I do. And so I think it's important to remember people hopefully are acting in good faith. They're trying to be good advocates for their clients. Sometimes we win, sometimes we lose. However, there are times when you're engaging with the other side and they do something that is not in good faith, or even worse, it's just not trustworthy. It proves well beyond questioning their credibility. You've proven in your discussions and perhaps with a resolution from the court on the issue that the information that you were given was not true. That's where I think the rubber meets the road and you have a real difficulty in coming back from, I don't trust that person.
So Mike, it's Tessa. What I'd like to add, and I usually am on the defense side, I will admit that. But what I do think I still see, and Ariana, I haven't been against you, so I'm sure this is not you, but I still see a lot of requests that are just simply facially overbrought. I mean, it's almost impossible for me to even come up with the matrices that we need. And so I think it's a good reminder that the rule doesn't just apply to the responding party, right? Like the requesting party has an obligation to issue discovery that's proportional. And sending me a request for asking for every single communication in an employment matter, every communication that the former employee had with the company, every text, without narrowing it down. The judges talked about that on their panel, right? Like, so we as attorneys have an obligation to send proportional discovery. And then what I would say is when you're responding and doing objections, I try to tell my associates when they have me review things, the word proportional, not proportional, it is a trigger. You need to make sure you substantiate why something is not proportional. So I think that will. That's
great. That's great. Thank you, Tessa. Listen, we've got a question from the audience. I want to keep it a little interactive here. And the question is, how do we achieve proportionality in third-party subpoena practice? And I'm going to start with Scott, but everybody can dive in here. Third-party subpoenas, my friend.
Yeah, sorry, I wanted to mute myself just to get any background noise. But no, I think for me, how I tackle third-party subpoenas is, again, I have a dialogue. What do you actually need from discovery from me and my client? And I try to scope it, and I have a very candid dialogue. If you need 10 custodians and 1 billion search terms and a 20-year date range, here's what the impact and cost is going to be. We need to filter that down. So I have an informed dialogue, and I try to make it iterative and try to get them some discovery early if it's appropriate, so that can hopefully inform their decision. I very much appreciate a requesting party, because I'm on both sides as well, that says, I don't know what I don't know because I don't know your client's systems. I don't know what you have. And so I need to have some information exchange to be able to be more informed and articulate a more proportional approach. So to me, I feel like having that candid dialogue, an active meet and confer, and try to get them some records or information early, hopefully can inform it, the decision and actually scope it much more appropriately.
That's awesome.
Mike, I would add on that. So when you're receiving a Rule 45 subpoena, one of the most difficult things is you got to respond quickly, right? And serve your objections, because you need to preserve your ability for cost recovery. So I think that's important to remind our audience. And the second thing is, it's really difficult when I receive a third-party subpoena to make any of the arguments regarding relevance or why something is important, because I don't really know the case, as Scott mentioned. So I think what Scott said is the most important. Pick up the phone, reach out, and say, what do you really want, and how can we work through this?
And I have an actual letter that I send when I get a disproportionate third-party subpoena saying, if you really want me to do this, here's the cost. Are you going to pay for it? And more often than not, when they see 6 figures, the answer is no, and they're willing to come and have a meaningful dialogue with me as well.
Well, I was hoping you were going to say that you have a letter that says, I read your subpoena and I invite you to a teleconference or a Zoom conference so we can talk about what your case is about. Obviously, we're not a party to the case, and I think perhaps a dialogue will facilitate our narrowing the scope of what you're asking of our client. Again, we're not a party, and we want to avoid any kind of litigation on these sort of side issues, which could result perhaps in costs. I think that in a way the third party piece is the discovery light, and I don't want to be quoted on that because I haven't fully analyzed that concept, but the conversations, the meet and confers, the iterative process that you're going through with another party is going to be throughout the course of the discovery period. A non-party or third party is not expecting to be pulled in indefinitely or even for the length of your discovery process to go through that same iteration. They want to be in and out if they have to even be in. And so I think you have to at least have that conversation similar, approach it similarly. If I was serving a third party, I'd want to have that conversation with Scott and say, tell me what you have. This is what I'm looking for. Is there a way that you can get me information in a really refined way so I can be on my way and you can be on your way?
And I should have said that letter comes after maybe there's not that negotiation and limitation.
It would never happen between us, Scott, ever.
Fantastic. Thanks so much.
Welcome to the table, so appreciate you coming.
Thanks, guys. We've got another question. I actually want to turn to Mandy because I think it's really apropos to some of the work that Mandy's doing. And that question is, in determining whether discovery is proportional, do you take into account the difficulty in collecting the data?
Absolutely. That certainly is one of the principles around proportionality, is to look at the burden, effort, and cost. And we're going to be talking in a few minutes about how you create metrics to facilitate just that.
I agree. I think that burden is I mean, frankly, it's in the rule, right? So I think you have to consider it. All right, let's in the interest of time, let's keep moving here. This. So would you trade a live dog for a stuffed animal? Is that proportional? I want to turn to the panel and ask you each, just really briefly, to define for me, what does proportionality mean to you as briefly as possible?
I can start with that. I mean, to me, proportionality provides a legal, defensible approach that helps with the alignment to right-size discovery to the merits of the case.
Ariana?
Thanks. Proportionality allows for the parties to get to the key information that will be necessary to determine the prosecution, the successful prosecution and/or the successful defense of a litigation. And each case is an individual case. You have to look at it independently.
Tessa?
To me, proportionality allows you to treat each case individually and to make sure there's a balance. Like I always think about it, is it fair, and how can we make it fair on both sides?
And Scott, what do you think?
I can't follow. I mean, I can't add much more. I mean, they obviously they hit and I really what resonated with me was actually Craig Ball's one of his takeaways was think. What do you actually need and what do you want? And that really resonated with me. That people don't actually take a step back and say, what evidence do I actually need and want? It's there, or it could be there. And I think what's not proportional is the finder's fee I had to pay my 2 daughters to film this video for the conference. So that was not proportional, if you know what I mean. A lot of Robux was paid.
And we'll speak to Bill about getting some kind of token gift out to them for their performance today. Moving on, we've got another poll question to kick off our next subject. When proportionality arguments are raised, what information is needed to intelligently discuss the issues with an adversary? Take a minute, fill in the poll. We'll put the results up shortly. And then we will kick off. I like this one too.
Metrics? We talking about metrics? Come on, man.
Just to keep you entertained. Poll results coming. There you go. And let's leave those up for a minute while we launch into our next slide. And I'm going to ask Mandy to take over here and talk to us a little bit about the information that needs to be gathered to have an intelligent proportionality conversation.
Sure, I'd be happy to. So I'm going to focus on metrics as well as a framework. And I think just as a starting point, I want to make note that when you're thinking about a proportionality analysis, it really needs to be based on fact-finding and information and not speculation. So in order to create a proportional discovery strategy, you need to actually have a framework with inputs, metrics, and outputs that allow you to create a defensible, consistent approach. So we're going to talk about the first stage, which is the evaluation stage. But we have 3 different metrics that we want to compile through this exercise. And the first relates to our custodians. Early on in the scoping process, we want to go through an exercise that allows us to evaluate the custodians to understand who's most important and who's least important. So certainly there's objective information that we would gather in regards to their hire date and their positions, but more importantly, we want to understand the information and the knowledge that a person has that relates to the fact pattern or the claims and defenses. So by constructing a short assessment interview that's conducted by the lawyer, where they engage with the employees to ask these questions, what we're trying to accomplish is coming up with a mechanism by which we can score those answers, recognizing that not all claims and defenses are subjectively equal. So coming out of this exercise, we have a cumulative score that allows us to very easily identify who's most important, while also identifying the people that are marginally important. And in certain instances, depending on the scope of your initial legal hold, sometimes you can actually release custodians from hold if you deem that they have no relevant knowledge or information. The second thing that we want to look at are the data sources. And historically, when a case starts, the employees will complete a data usage survey, which is intended to capture information about data sources and locations. And those responses traditionally become the basis, which kind of informs what we do from a collection perspective. The challenge there is that an employee doesn't necessarily understand if a data source is truly unique and relevant. So by having the legal team engage with the employees to evaluate those responses, we have an opportunity to set aside data sources that may not be relevant to the matter at hand or may be duplicative. The metric that we want to generate here relates directly to burden and effort of collection, which was based on the earlier question. And there are really 2 sets of factors. One are technical factors that relate to each data source category. And secondarily, you may have factors that are custodian-centric. And what I mean by that is if you're collecting a computer in Germany, the burden score on that may be higher than collecting a computer in the US. But coming out of the second stage, you can see that I clearly understand where the low-hanging fruit is as far as data sources. I've also carved out my burdensome data sources, and hopefully I've left behind some data sources that are not relevant or duplicative. The third metric revolves around cost estimations, and this really has been a challenge, understanding what the costs look like in front of agreeing to your discovery strategy. So you're going to create a series of inputs and assumptions here that relate to each data source category. Certainly, we recognize there are a number of different ways in which you can approach the e-discovery workflow, and so that needs to be incorporated into your calculations. And then you also may want to rely on historical information from the client in similar litigation. But coming out of this fact-finding exercise, we're going to have the information and the metrics that we need. If you could move to the next slide, Mike, sorry. We're going to have the information and the metrics that we need to scope, evaluate, and budget the proposed discovery plan. So what you see here is a roll-up of those metrics from the first slide, where the custodians and the data sources roll into specific quadrants based on their relevancy ranking and their burden and effort ranking. So looking at this, the center of the bullseye is my upper left quadrant, highly relevant, easy to gather, and ideally from a discovery scoping perspective, we would want to start our negotiation process here by selecting certain custodians and data sources. And remember, with the cost estimation information, as we're making these decisions, we readily understand what that may look like from a standpoint of discovery spend. The upper right quadrant also falls within priority relevance, but these are burdensome in nature. And so this is where we really need to evaluate the evidentiary value and the cost to move that data forward and whether it outweighs its likely benefit. And from a standpoint of evaluating data in these quadrants, sampling is certainly a mechanism that allows us to look at the content, to determine the density of information around the claims and defenses, and then ultimately we may decide to pursue cost sharing or cost shifting to mitigate the expense for the producing party. The bottom two quadrants is really where you get a lot of value from this early scoping, because rather than moving them forward, what we're suggesting here is, since they are low relevance, the likelihood that we're going to find highly relevant content is marginal at best. So ideally, we want to sample to support our strategy around removing this from moving forward in discovery. So coming out of this secondary step, we're ready to talk about negotiation. If you can move to the next slide. So this represents the output of the model, which gives us a roadmap of the attorney decisions relating to the custodian priority or relevancy, the data source burden and effort, and the cost associated with each of those data sources. So you really want to think of this as your starting point for the creation of a negotiation strategy. And by selecting custodians and data sources in these upper two quadrants, you're really focusing your discovery effort on the most significant content. You may also want to contemplate constructing counter proposals from other parties so that you can look at what they're requesting that you do. And the goal there is to understand the budgetary impact and also to evaluate whether the counter proposal is proportionate and aligns to the merits of the case. So ideally, after this negotiation process is concluded, you're going to finalize this discovery plan detailing all of the decisions that have been agreed upon. And preferably, we want these decisions memorialized in an ESI protocol. So just a couple of comments. The perspective from the bench is that this written record really gives them the points they need regarding attorney decisioning, as well as the metrics, so that they can rule if there happens to be a proportionality dispute. And I think lastly, it gives you centralized documentation around the legal thought process, not only as a historical case record, but also for use in future discovery processes as the case evolves. So with that, Mike, I'll pass it back to you.
Thank you so much. Great information, Mandy. Useful no matter where you are in the practitioner spectrum. But I want to turn to the rest of the panel. Ariana, thoughts on this?
So I think it's great when people like Mandy think through the actual process. I mean, what she's put before you is very logical. It's rational. I might not agree with the inputs and the outputs that come out of her process, but I can have a conversation with somebody like Mandy who comes to the conversation with real data points. and they're data points about the data, right? So to the extent that there is an issue about the volume of data, we certainly want to be mindful of the fact that there is an end game for litigation. It's not lots of discovery. The end game is the resolution of the matter. And so for me, I don't want to be in a situation when I'm a requesting party to end up with a data dump. I would rather have a conversation with somebody like Mandy who says, okay, look, we have a lot of data. This is the process we've engaged in, and we can give you some pointed examples of why this information is priority relevance and should be produced in a prioritized way, and where as we start getting into these other areas, it's going to be more challenging, and we may find ourselves not agreeing unless we can come to some understanding based upon our discussions here. I mean, I would love to have somebody like Mandy on the other side of me to have that kind of conversation.
I think
Awesome.
one other comment I would mention there is that, this is an artificial intelligence, right? This is attorney decisioning. So ultimately, if Ariana wants to get into specific data points and where those came from, you have the ability to substantiate that conversation. I mean, you have a consistent process that's been undertaken to reach those conclusions. So certainly, you can always agree to move things around between the parties if that's applicable, but at least you have a baseline from which to start.
Right, and that comes back to the Groundhog's Day issue, right, Mike? So where you end up having an opposing party, and in response to your requests, you get the, oh my gosh, there's so much data, and it's just disproportional, and we don't even know where to start. Well, guess what? You don't know where to start. We're not starting. We're not actually launching into a conversation because you've just kind of given me a lot of histrionics, as opposed to something I can work with.
Fair point. Very fair point. Tessa, did you want to add something?
Yeah, I was going to say, so, I work with a lot of institutional clients. I think documenting a lot of what and using the information from other cases actually does help me, because I do try for every client I work with to really gather information regarding their IT systems and then gather metrics. For burdensome arguments, I think someone asked the question, how do you assess that? I from a case, I ask IT and clients to keep track of how long is this taking us to do, so we can quantify that a little bit more. And then I was going to say, I saw a question in here on how do you, for a third-party subpoena, like some cost shifting, how do you handle that? And I think, especially with third-party subpoenas, I found that requesting parties, we can be a little creative. Like, instead of, if the biggest cost for me is tiffing what they want, well, maybe I'll give them, a reconstituted PST, and they'll tiff it and give it back to me. So I think Aaron's right. We need to have a lot more discussion before we throw up our hands and say this is too much.
All fair. Scott, anything to add?
There's a lot of questions I see in the chat about kind of cost sharing, cost shifting and how it interplays with proportionality. And I do think there's an open dialogue, but I given a war story here, I'm very mindful and careful about raising cost sharing and cost shifting unless it's absolutely appropriate. Obviously, the rules generally states that the producing party bears their own cost for discovery if it's proportional. I can tell you, I have a lot of clients that aren't interested in allowing another party to buy discovery. And so even if somebody's willing to pay for it, you have to really assess, is the information worth discovering? Is it relevant to the claims and defenses? So just because there's cost sharing or cost shifting involved, I'm very mindful about, am I obligated to give it? Do I need to give it? And is it important to give? Because there may be other things that impact. And please remember, as a producing party, even if I do give it over, I still have to know what's going over to the other side. I have to be able to understand, I have an ethical obligation to understand the data that's being produced. So it's not necessarily just free hand the data over. And then one other comment on this in the interplay of Federal Rule of Evidence 502D. I've often received a lot of questions or comments from adversaries that say, I can add 10 custodians and all these search terms, and there's really no burden to you because you can produce without review. You've got to get out of jail free card. You have 502D. And I would argue, no, I still have costs. There's processing. There's the production costs. There's the technical, the ongoing hosting issues and charges, because once I produce it, I have to maintain it for the life of the matter. I have to understand what's going out, and you can't unring the bell if there's documents produced. And I promise you, most of the parties on the other side don't want to host an extra 200 gigs of data from the receiving party side. I think sometimes it's a little bit short-sighted on that. Is, do you really also want to host that much data? So even though I see a lot of people talking about cost shifting, I just caution, based on my experience, it may not always be the best argument. There may be other ways to tackle getting to the actual evidence needed in the case.
Yeah, and Scott,
it's a great point.
Like the review cost is usually the highest cost,
Yeah.
and most courts don't allow you to shift the review costs. So I think that's one of the issues.
And it's a great point, and just not to put too fine a point on it, but the point of this is be careful what you ask for, because at some point the other side, the judge, or even your client is going to say, "Show me the money!" Show me the metrics. We couldn't find anybody to say the word metrics, so we just went with what we had. Okay, let's move on to our final section. Let's suppose you're on the receiving end of a proportionality argument from your adversary. Our next poll question asks, when a party does raise the issue of proportionality, what's the best way to assess those arguments? We'll take a minute to fill out the poll. And then we will move on. Look at that. Use the factors. And we will turn at this point to our friend Scott, who frequently finds himself in this situation, assessing those arguments as they're coming in. Scott, what are you doing to determine whether a proportionality argument actually makes sense?
Yeah, well, I mean, obviously, we may have a little bit of a fandom of Jerry Maguire. So for those that enjoy that movie, you see a couple from here. But from my perspective, when I'm assessing proportionality, is I am really looking at the requests as they come in. I have an independent obligation to respond to discovery. I'm signing, 26G saying I am looking for taking a reasonable approach to responding to discovery. So for me, sometimes what the other side may not actually matter to me in the beginning. And I say that because I want to actually set a baseline. I know what I think are the right custodians, the right search terms or other use of technology to help me get me there. And I set that floor, and I start to build metrics around that floor. I've never had a requesting party tell me, oh, no, you don't need to include that custodian. If I know they're likely to be relevant as a person representing, I'm going to go ahead and propose those folks as custodians and move forward. Then when I get requests back that say either add these 10 custodians or these 100 search terms or whatever it may be, I then like to have a dialogue and explain, okay, let's see where do you think you're missing in discovery? Is there alternative ways to approach the exchange of information? Can I tell you a little bit more about why these custodians may or may not be relevant? And if I have somebody on the other side that understands that back and forth and is willing to listen and have a tailored and focused discussion, then proportionality, I don't need to go to the court seeking relief. And generally, I'm not feeling a motion to compel or responding to a motion to compel because we have had a dialogue. I also will take a lot of approaches to look at search term sampling. If we are still in the search term world, sample the delta between my terms and the requesting party's additional terms. Because if I share the richness, and in my experience, when I share the richness of the responsiveness of those additional terms, and if it's low, more often than not, my adversary says, okay, I get it, right? Going back to the factors, one of the factors, the additional 6 factors, is whether the burden or expense of the proposed additional discovery outweighs its likely benefit. If you're asking me to review an additional 100,000 documents for 2% additional responsive documents, I would argue that's not disproportionate. So that's some of the ways that I look at handling and assessing whether I want to raise the argument, or when somebody's coming back to me and just says, here's a search term hit report, it has 300,000 documents. If they've done nothing to test or help me, it's a little bit hard for me to be informed on how I tailor my request a little bit differently. Mike, you're on mute.
We're going to turn to our panel in a second, but I have to just say, Scott, you make it sound easy.
Easy peasy lemon squeezy.
Let's turn to our panel. Comments on assessing proportionality arguments, Tessa?
My comments, many of them would be the same as Scott's, but I would say, I still live in a world where, half the cases we're using TAR on, and there's half where we use a lot of search terms still. And I think what Scott said, providing sampling, providing the numbers, the hits, testing my search terms versus what the other side wants. I still see a lot of people that don't want to provide numbers, and I think I don't know how you can do it, how you can validly make an argument. Especially, I don't want to be in front of a judge saying I refuse to run certain terms and not having provided numbers. And if I am refusing, I've really sampled the heck out of it, and I know why. I can make my arguments, and then I've also suggested. I do find that it's better not to take a hard stance, because it's going to come back to bite you later. And so that transparency and cooperation, I really believe in it, especially during the discovery process, and when you're dealing with cases with a lot of big volume. I don't think you can take a hard stance.
And I just wanted to add some simple alternative requests when you're asking for more data is, do you actually tailor the custodians and the date range that are in the relevant role at issue? I'm often being asked just to add 5 people for the entire relevant 10-year period, but they may only have been in a relevant role for 2 years. That's a simple cut that could actually make a huge difference on the effort of discovery. Same with search terms. Sometimes will give me search terms related to the entire case and run them against sales and marketing versus outside sales versus R&D. They may be completely different. It may be more appropriate to tailor your search terms based on the custodians and who they are. So just some simple ways to really not ask for all and everything and focus what you actually need to get out of it.
Mm-hmm. Yeah, Scott's right. You can tailor each custodian can be different date range, different search terms. And sometimes I find that people just add custodians when you don't need the custodians. It may not be in an email pool, might not be a custodial document, right? You can do a targeted collection.
Great.
Just one other thing, Mike. I mean, I think also having the other side tell you that there's a big difference if you include a particular year or a particular time period in terms of the output is so helpful. I had this conversation this week in a major MDL where by sharing not only the hits, but then breaking it down in the relevant time periods for the case, we were able to reach an agreement, and we were willing to say, okay, we don't need that part. You've got it, you're preserving it for the moment, we don't think we're going to need it, but let's get this stuff here prioritized. And again, it comes back to that constant conversation. Okay, you're telling me this is problematic and burdensome. Tell me why. And if I suggest to you, hey, let's change the connector. If we change the connector in the search terms, maybe that's going to really help. Tell me what the output is when we change the connector to this or to this. And maybe we close in the gap between, or maybe I just say, I'll take the first one, which is the smaller connector or the bigger connector. It's about the conversation.
All fair commentary. Mandy, anything to add quickly, and then we're going to move on. We're running short on time. I want to get the takeaways.
Well, I think proportionality is a tool in the toolkit. I think the 2015 amendments were modified to kind of reflect that. And for litigators practicing, having a competency as to how to leverage this from the onset of a matter and continue to use it throughout, I think has incredible value from a standpoint of managing a reasonable discovery process.
Awesome. Thank you so much. All right, let's turn to a couple of takeaways. So we covered a little bit of ground here today. And I'm sorry, there's a ton of questions out there. We're not going to have time to get to them, but we'll figure out how to answer those questions. We'll get back to all of you. Scott, why don't we start with you? The first couple of bullets here are yours. Takeaways for our audience today.
Yeah, being respectful of time. I mean, I think we shared a lot of this throughout the panel, but to me, it's come prepared. If you're coming to a meet and confer and raising just the word proportional and disproportionate and burdensome without anything there, often I don't see anybody being like, okay, you don't have to do that discovery. Come prepared to offer different solutions. I've seen a lot of folks weigh in on the LinkedIn chat about what about solo practitioners and small case discovery. You know what? Maybe screenshots of certain data, maybe printing the PDF is appropriate in certain ways to get to the end, get to the underlying evidence. So think creatively on how to respond to discovery, and maybe more importantly, think creatively how to request discovery. And that goes a little bit about what I was just sharing before about, do you need everybody for the entire time period? Can you focus in on what you actually need and then make it iterative? And then metrics do not need to be perfect, but based on actionable data. I always hear people say, I just don't know it. How do I know without doing it all? There's a lot of industry knowledge about the number of docs per gig, and you probably know some information about the sources. So just build something and make sure it's reliable, document how you process it, and then have that dialogue. I think coming with something is better than nothing, and there's no such thing as perfection anyway. So those are my big takeaways.
Thanks, Scott. Ariana, your takeaways?
Yeah, I'm going to be quick. The next three are mine, so you can read them on the screen, but the two most important are: remember that the end game is not discovery. It's about proving or defending your case. So can we just get to it? Let's narrow that discussion and get to what really matters in the case. And the other one that I feel very strongly about is really paying attention to the timeline of your case. If you're meeting and conferring and you're not getting anywhere, and you started discussing your ESI protocol 3 months ago, you also started discussing a privilege log protocol, now you're 9 months into the case, you've not gotten a privilege log yet, guess what? You either have to fish or cut bait. You're either going to say, this is my last try at resolving this, let's go to the court. Similarly, on proportionality, if you're having a fight about proportionality and you're making no inroads, you've got to set an internal deadline and say, if we don't have an agreement by this date, we're going to the court. That's when you're going to have a decision, one way or the other, either because you reach agreement or the court's going to give you the guidance you need.
Thanks so much, Ariana. Let's keep it moving in the interest of time. Mandy, your takeaways?
Yes. Well, I think documentation is a huge part of adding defensibility to this process. So you really want a strong written record of all the decisioning. And I think you'll find that information is useful and can be referenced throughout the life cycle of a matter. And then I also wanted to touch on that centralization of documentation is becoming even more critical in the corporate sector, because now we have all of these privacy requirements. And so from a mitigation of risk perspective, it's really essential that there's collaboration between the law firm and the client around all things relating to decisioning, so that if you have to defend things that happened or didn't happen 2 years down the road, you have the ability to audit and explain why certain decisions were made.
And I can't let anybody mention the word documentation without putting in a plug for project management and e-discovery. It's just something that, it's part of the process, right? It's absolutely necessary to make the process defensible. Let's turn finally to Tessa. Your takeaways.
Thank you, Michael. I would say, start by prepping your client early. A lot of clients are misinformed too. They hear the word proportionality and they're not thinking of statistics and everything that you have to gather. Start early, and some of the tools that some of the other panels talked about are very helpful at this early stage as well. I would say think beyond price tag. There are 5 other requirements in proportionality that you can think about, and there's some recent cases that are out that where the producing party focused on just the price tag issue, but the court focused on all the other 5 issues. So be careful with just focusing on price tag. And then be careful with taking a hardline stance, because it may come back to bite you later. And then the final thing I'd add, which we didn't talk about a lot, but think about proportionality and preservation decisions. I find that if you raise that with the other side, especially for some of my clients where preservation is difficult on some sources and really not necessary, why guess? Why not take that argument and go and talk to the opposing counsel and figure out, can you think about proportionality when it comes to preservation as well? That's all I have.
Fantastic. All right, we've got 2 minutes to go. I don't have anything to add. Does anybody want to take 30 seconds and add something? I can try to dig up a question from the chat, but they're all buried at this point.
There was one on breaking up families and prevailing wisdom. I thought that was an interesting one. That's something an approach I've taken as a producing party, where I haven't broken up families as much as attempted to enter into an agreement with the opposing party saying wholly non-responsive attachments attached to an otherwise responsive document on its first instance can be slip-sheeted. And part of my proportionality argument is if you can do that, then you don't incur the cost for priv review or second-level priv review. You also don't have to worry about potential redactions for PHI, PII, or any kind of data privacy issues. Whether the case law supports me, I think there's a split in many jurisdictions on that issue, and which is why I try to have that dialogue in the meet and confer.
So there's another interesting question, and if somebody could do it in 30 seconds, great, and that is, and I'm going to abbreviate the question, AI discovery tools, what role do they play in the proportionality calculus? Panelists?
I mean, I think if you go to the court arguing burden and haven't taken into account efficiencies in your process, if I was a judge, I would question your metrics. If you're not taking into account use of potential threading or technology assisted review or other alternative workflows, I think you lose credibility. Because it's going to be $2 million when you can drive in a more efficient process that maybe is only $500,000.
Right. I think there's a few courts that have cited exactly what Scott is saying. They ask that question.
It's a fair point. We have run out of time. Professor
Thank you,
Hamilton
Mike.
has
Great
joined
job.
us. Thank you so much, Mandy, Ariana, Tessa, and Scott. Thank you, UF Law, and thank you, Professor Hamilton, for having us today.
Yeah, thank you very much.
Thank you.
Bye-bye.
Bye.
It's our pleasure. Thank you very much, panel. Wonderful job on that really critical topic that we're facing right now in electronic discovery.